myself. My name is Leah Rachin, and I am the town attorney, and I work with the firm of Bergen and Parkinson right down the road in Kennebunk, and I see plenty of familiar faces. I see some new faces, and so, you know, I think the last time, I pulled my notes, and the last time I was here doing this was 2010, August 2010. And so it's been a while, and, you know, these concepts are tried and true. There have been little changes here and there on the right to know law, but, you know, for some of you, this is a 101. For some of you, hopefully it's a 301. And what I want to do, my style is, particularly with these issues, I mean, we're dealing, as I understand it, that we're dealing with quite a few boards, at least Board of Selectmen, Board of Appeals, Planning Board.
Budget Board, Rec Committee.
Okay, so we got quite a few boards coming. So, I mean, this isn't a one-size-fits-all necessarily. I'll go into certain things that might be more applicable for a Board of Appeals, say a Planning Board, but general concepts do apply. And so what I'd really, really appreciate is it to be more in the nature of a conversation. I mean, Lord knows you get enough time, people with lawyers yammering on and blah, blah, blah. And a lot of these concepts, they really do kind of come alive when you talk about, if you have questions, if you talk about your own experiences. With that said, I would say let's try to keep it more hypothetical than any particular application, particularly if it's a pending one. We don't want to talk about those things. But, you know, as I go along, please, I beg of you for your brethren and your everybody's benefit, and also for mine, because it'll make it much more interesting. Okay? So please, feel free to jump in. And if I see, today, Todd and I were communicating because I had said, all right, well, make sure if there are particular issues that are coming up or if people have questions, make sure they get them to me so at least I can, you know, address them. And of course, he said that the most frequent question was, so how long is this and when do we get out of here?
Yeah.
So,
Got a lot of that today.
I'm going to try not to take that too personally. But again, I know these aren't always easy concepts, and if I see you glazing over, maybe I'll get up and do a little soft shoe, and you know. All right, so let's start. I think really good place to start is the freedom of access law, FOIA, right? You know, the right to know law. And I did circulate a sort of primer from MMA. And, you know, I'm going to really just kind of be speaking casually, but if you ever have a question or, you know, you have insomnia and you need something to help you go to sleep, I shouldn't say that. Actually, MMA, I don't know what I would do without them. They're phenomenal. They're a great resource. But, you know, I think the right to know law is one of the things that you want to start out with because it kind of is the foundation for local municipal government, right? I mean, that's kind of why we're here. And really the two most, I mean, the overarching concept, of course, is that decisions, local government, should be out in the open. It should be basically so citizens know what decisions you're making and why you're making them. And that's really what it's all about. So let's kind of go peel back the layers of the onion a little bit. So on one side we have public records. On the other side we have public proceedings. And basically, like I said, the informing purpose of the right to know law with respect to both of these things, it's the same. Let's do things out in the open. So let's talk about what a public record is. A lot of this stuff seems really obvious, but it isn't always. So a public record, I'm going to throw a little jargon at you, a little definition, but basically state law defines a public record as any written, printed, or graphic material that has been received or prepared for use in connection with the transaction of the public business. So that makes sense. If you receive a document, if you send out a document, if you prepare a document for anything that's related to the transaction of the public business, that makes sense. But here's where things can kind of get people into trouble, and I've seen them get into trouble, so let's talk about it. There's the or. Or contains information relating to the transaction of public business. So that's really broad. That's a really broad, it's a broad definition. So let me ask you some questions. I mean, do you think the town payroll records are public records? I see nodding, that's good. What about an email between board members? Okay, so let's...
Well, that depends.
Good, I like that.
Yeah.
That, you know, it's usually lawyers saying that depends. I'm glad to hear that you guys are saying it. So what does it depend on? Tell me what it depends on.
Whether it's personal or board business.
Okay,
And
so...
if it's board business, it shouldn't be highlighted.
Good. unless it's about where are we meeting, here's the agenda, and then no discussion whatsoever. So you're good, you got that one, that's great. So yes, if it's about business, no brainer, it's definitely. What if it, and you said if it's a personal email. Okay, well what if it's a personal email to your wife, your best friend, saying, God, you know, this planning board matter, it's a beast, and I'm not quite sure what to do with it. I think I'm going to do some personal research on it, and by the way, God, I can't stand that applicant. Okay, so that's a personal email. But is that about the transaction of public business?
You'd have been okay if you hadn't commented on the fact that you can't stand that applicant.
Okay, that's definitely one
No,
thing.
that's legitimate. You cannot stand an applicant. There's no
I don't-
reason you
But
can't.
should that be your outside voice?
No.
As I say to my child, as to my son.
Still, legally,
Yeah.
that is not a problem.
I think I'm going to challenge you on that, and we'll
Yeah,
talk. We'll
I'll
talk about.
challenge you back.
Yeah, and that's fine. That's what I thought. Okay, that's what we're doing here. But one of the concepts that we'll talk about, and why don't we just talk about it now, is bias, right? And there's a bit of a segue here. Part of the right to know law that we're talking about, it's about process, right? It's about fair process. The concept of due process, right? The whole concept of due process is that your applicant, people before you, they need to have their day in court and make sure that the decision makers, whether it be the planning board, whether it be the board of selectmen, budget board, well, all of the boards, if it is a, we call it a quasi-judicial decision. Basically, you're the judge, planning board, boards of appeal. You're making a decision, right? And the board, the person or the board that's making the decision, should be fair and impartial. So if a member of a board who is making, say it's a planning board, right? Say that planning board member says, I can't stand this applicant. Well, arguably, and I think it's a pretty strong argument to say, they're not getting a fair deal.
No.
Okay,
No.
so you tell
You
me.
may, just because you don't like somebody, doesn't mean you still can't turn around and be fair.
Very true. Now, I agree with you 100%. So that's where, sometimes things, there's black, there's white, and there's gray. And that's gray. And some people certainly are capable of making an objective decision. What I'm talking about is when I get the appeal from that decision because, for example, they did a document request and they got that email that says, I can't stand the applicant. Well, you can say, I'm impartial, just because I don't like you doesn't mean I didn't make the right decision. Say you can't stand the guy. I mean, if you made a decision that was in his or her favor, then you're fine. But if you made a decision that you denied it, let me just finish. What's going to happen is this. You can say, I made an objective decision until the cows come home. But when you get served with a lawsuit and Exhibit A is, I can't stand the guy, you might win in the end of the day, but it's really not best practice, and it's not something that you want to have to defend. So that's what I'm saying. I mean, you can certainly govern yourself accordingly, but I'm telling you that it could possibly cause a lot of headache, and in the end, you might win, but it's not something that is best practice, and that's what I'm here to talk about. So, all right, I'm going to go back to right to know, and we can get back into conflict of interest and bias issues, because they're juicy, right? I mean, they're interesting to talk. They're interesting to talk about. Okay, so with respect to public documents, public records, and I mean, Simone, she's the expert over here, but now it used to be, it was almost every man for themselves, right? Every board for themselves. Now, at least, the law requires, and I'm looking at Todd because I have a haunting suspicion it's you, the Freedom of Access Officer.
How'd you know, Leah?
Right? I got a haunting suspicion. So, the good thing for you all now is that if there's a request, you say, hey, Todd, I've got a request, and then you have to go through and respond to it. So let's talk about that. Back to emails. Back to the wonderful world of social media. Now, the hot topic now in the right to know law is sort of that intersection between social media, Facebook, LinkedIn now, and email. And, a lot of people, and it makes perfect sense that you wouldn't think, well, this isn't a public record. And it's easier to understand, well, it is a public record. That's easier to understand. But where it gets a little murky and a little more interesting is it's not just a public record. Now we're getting into a public meeting, right? Because the definition of a public meeting is if it's, say, it's, 3 or more members of the board, okay? A meeting doesn't have to be us all sitting around a table. In fact, it isn't. You start talking about an application in front of you or a board of selectmen agenda item. And if you're talking about the substance of it, that becomes a meeting. It might be in cyberspace, but it's a meeting. And it's a no-no. And why? Well, we're back to the right to know law. We're back to due process, right? So an applicant, if they have no idea that there's been chatter about the substance of the application, then that means that they may have not had an opportunity to address a concern, and that they may have been, their application may have been denied for reasons they had no idea about. So those are the things that, we need to think about. And so many of these right to know law violations, I really truly believe have nothing to do with ill intent, have nothing to do with bad people making bad decisions. It's simply oops. So what happens if there's an oops? What do you do? Is the sky going to fall? Your mother's not going to love you anymore, and you're going to rot in jail? I mean, is that the upshot? What happens? So say you do send an email about the application, and you realize, oh boy, shouldn't have done that. Any thoughts on what to do?
Maybe disclose it.
Yep. And all is not lost. That's exactly right. You disclose it, and you give the applicant or whomever it may affect the opportunity to respond. You even print it out before you come to the meeting if you realize. Make copies, say, oh, by the way, I realized that I had done this, and no harm, no foul. As long as the people get an opportunity to address whatever that concern was, then it's totally fine. Another example that I ran into a lot, and it falls into the category of not only not bad people making bad decisions, but good people trying to be diligent. So a lot of the time on a planning board or a board of appeals, there's an issue before them, and they think, oh wow, this is really interesting. I think I'm just going to do some research on it, right? I'm a nerd. I like research. That's what I do. I want to inform myself about things that I don't know about. Well, what do you think? Is that a good idea? Should you do it? And let me back up. I'm not saying is that a good idea in the real world. I'm saying is that a good idea legally speaking? And I understand that sometimes those two things don't necessarily, concentric
We do live in
circles.
the real world.
Right, we do, but we
Not the
also.
legal world,
Well, I think as a municipal, somebody who's, well, my opinion is,
especially local government,
particularly local government.
real world.
I would think that the problem with doing that research
Yes.
is, what are you looking at? Are you looking at Wikipedia
Yeah.
to get your answer? Wikipedia is about as unsafe a place to get a response from. And you only, our problem, and I don't know about anybody else, when I go do research, I find the answer I like and I'm hanging my hat on it. And that may not be the only solution to the issue that is out there. So I think it would be better to have an expert come before the board and discuss whatever it is that's going on, as opposed to my doing the research. Because I can find the answer I want.
I disagree with you, Rich.
Oh, no, I can find the answer I want.
Yes, I know that, but each member should do research, and each member should be as informed as they can be, and then listen to the testimony, and then make their decision, and also discuss with the rest of the board at the meeting what they have learned.
And that's
During
key.
the research.
Let me back up, because again, I think I'm gonna challenge you on that about the legal aspect of that, because the law says, and the case law says, again, this may be contrary to common sense, but the law says that it's actually a violation of an applicant's due process for folks to do their own research, okay? You're supposed to be like a judge, and a judge is supposed to go in and is supposed to listen to and that's exactly what you're doing. Board of Appeals, Planning Board, you're a judge. You're supposed to listen to the evidence presented to you, and then you are supposed to make a decision about that. Now, that's not to say, back to the real world, that you have to forget everything you actually know as a human being, okay? And that's not to say, and I like your point about the expert, that the expert doesn't always win. So let's peel that back a little bit, okay? So if you do your own research, that again is that situation where you print it out and you say, hey, this is what I found. These are what my concerns are. applicant, have an opportunity, address them. What do you say to that? Why, just give them an opportunity. Again, we don't live in a vacuum. We all come to our meetings and our respective boards with pre-existing knowledge, and maybe we did do some research, but if we did, you gotta tell them what you think so that they can address it, okay? Experts, common sense, okay? So say you have an applicant and, to your point, you said, I can research anything and find an answer I want. Well, that's advocacy, and you're gonna have lawyers in front of you or somebody it's their application. They're gonna pitch it and pitch it hard, right? If what the applicant brings to you, even if what an expert brings to you, just is not jiving with, let's face it, you guys live in town. If some traffic study says X, and you've been at that intersection every day for the past 20 years, and that's just not true, you don't have to accept it. You just have to say, I disagree with you, and this is why. And sometimes basic common knowledge, personal knowledge, is absolutely sufficient and can trump an expert opinion. It's all about saying why. This is what the evidence is. We prefer this evidence, and this is why. And that's totally kosher. So.
But you're saying then that the members should do research, should be well informed, so they can listen to the experts and judge whether the experts are telling the
Nope,
correct,
that's not what I'm saying.
giving the correct data.
Nope, that's not what I'm saying.
How can you judge the experts then?
I think basically you are a volunteer municipal board. You're never going to be, half of these people have PhDs. There is no expectation, not only is there not an expectation, but as I said, there is almost a prohibition about doing oodles of research. You are supposed to take what you are presented with and make a decision based on that. If you do your own research, you're supposed to disclose what it is so that the other person can
How can
respond.
you-
Simone?
As I say, and if you have a question, I think the biggest concern would be to address the question and say, instead of doing your own research, saying, I think we need to look into this more, could you present more information, or can the town or
Absolutely, and
the,
that's another thing,
you know,
especially
get
with,
more
let me just
information?
finish, with the planning board especially, and I even think in your own ordinances, it says, in the event that we need a third-party expert. I mean, that's what I'm saying, it's like, I might be an expert in municipal law, but I know well enough that I'm not an expert in turkey husbandry, or, stormwater management, or whatever is before you. And that is why you have written into your ordinances the right, and dare say, in those situations, perhaps the responsibility to go out and get competent expert advice if there is an expert and on the other side there isn't, or if there's an expert and you just so, confused that you feel in order to do your job correctly. And what is your job? It's to look, for example, planning board. What are the ordinance criteria? I have to check the boxes to make sure these criteria are met. Based on the information provided me, I don't know. I need some expert advice. You are absolutely entitled and should get that expert advice. And the applicant can pay for it, so it's not like the town has to pay for it. Yes?
Okay, many times, just in general,
Yep.
that an expert comes, okay, and voices his opinion, quote, opinion, okay, but from practical experience, okay, when he speaks, thinks that it's law. And when practical experience, there are possibilities or anything else that are infallible or turn on, can be proven wrong. How do you turn on and judge that?
Well, I'm
Because not everything is written black and white.
Well, certainly not, and in fact, most isn't. So that's what I'm saying. I mean, that's the role. That's your role. That's your role as a decision maker. It's about weighing. It's about weighing what is presented to you and coming out with an answer. And the process is for planning. I'm not sure what board you're on, but say it's planning board. Say it's a board of appeals. Basically, I think the good thing about planning board approvals, for example, is you're not going in there blind. You got a roadmap. I mean, there are the criteria in the ordinance. You gotta, I mean, when I think about a planning board approval or planning board process, it's like a connecting the dots. You have the criteria, then you have the evidence in front of you. Does the evidence presented allow you to find that that criteria is met? That is exactly what you're doing. And I'm not saying it's easy, but the decisions you can make are, A, the stormwater report submitted by such and such shows that stormwater criteria is met. Check the box. They didn't, alternatively, they didn't submit a report that will allow us to conclude that that criteria is met because, and then you talk about the whole. Alternatively, you can say, we don't think that this stormwater is going to, the plan is going to work because we know the lay of the land. We've lived, we've seen it, we know how this works, and we don't believe it. Because, boom, 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 boom. So you don't, just because an expert is in front of you, you certainly don't have to find in his or her favor. You can rely on your own common sense and your own experience. You just have to say that in your findings.
But Leah,
Yeah.
why can you rely on your own common sense and your own experience, but not your own research?
For the very reasons I explained before.
However, when you're talking about cut and dry issues, fine, I agree with you. But when you get very technical issues, we had CMP come through a while back, very technical.
Yep.
To even understand what they're saying, you have to know what they're saying.
Or you can hire an expert.
No. The experts, I brought up issues at that meeting that their experts couldn't answer because they hadn't researched them.
But that's
So
fine.
why
So-
is it that I'm not supposed to do that?
Well, I
legally?
explained to you why. You can either accept it or not. But what I'm also
But it's
saying,
brought out in a public meeting, in front of the board, in front of the applicant is questioned
Sure.
on those facts.
Yeah.
What's wrong with that?
absolutely nothing. As long as you bring out the facts, your concerns, say what they are,
Right.
and let them address them. We're saying the same thing.
But that comes from doing your research, and you bring that to the board, and you bring that to the applicant at the meeting.
And what you're saying sounds like it is resonant, so I think we should
So
move on to the
that
next
is
question.
okay.
I'm gonna say it one more time. Ideally, you're not supposed to do the research. Ideally, you're supposed to take what has been given you. If you just can't help yourself, then you disclose what you've done, you ask the questions, you let them address it. That's it, okay? All right, let's talk about, back to the public record stuff. And Simone, you're a ringer, so you have to stop. You can't answer these, okay? All right, so what happens? So say, and I don't know if you guys have them, so many of my towns have the folks who, and they're entirely entitled to it, ask, because that's what the whole right to know law is about. But like serial records requesters, people who come in and say, I want every document from the dawn of time from 1653 or whenever, that was Kennebunk, but whenever the town was created, I want everything that was ever written ever. Is that a legitimate request?
No,
Actually, can you ask for clarification?
Yes.
But if they want it, are they entitled to it? Do you have to make it available to them?
if you don't have
At
it,
a
you can't.
cost.
True. Everything that has been said is absolutely true. You are not required by law to create a document that doesn't exist. If they say, I want a summary of every planning board meeting that ever happened. No. If they want, you can ask for clarification, and in fact, sometimes that works because they actually do want something more specific. They just didn't know how to ask for it. You can ask for clarification. If they say, no, I really wanted everything from the dawn of time. Do you have to package it up in a nice little bow with little stickies organizing it? No. Your duty is to make it available for inspection and copying. And as you say, you can charge for it. Unfortunately, is it the going rate? Absolutely not. The legislature, in its wisdom, just bumped up the fee from $10 an hour to $15 an hour. But the first hour is free, and you got to do it. Now, in the day of electronic, we have electronic records. Do you have to put it on a disk for them? No. If it exists already in electronic form, do you have to? Yes. Do you have to, somebody says, hey Simone, I need to sit at your computer for the next 3 days and go through your computer.
Life's tough, you agree.
Thank you.
Actually, I did do a freedom of information with the state several years ago, and I did sit at their computers and download
Well, if they make it available to you, certainly, if they choose to, but they don't have to. And particularly if there's, on that computer, there are lots of documents that fall within an exception to the right to know law, and there are plenty of them. Unfortunately, there's no list. They're all over the different statutes. But I mean, if you think it's better for you to have them sit down at a computer and look through it, great. But you don't have to make that available.
Well, that raises the question about email.
Yes.
I made a mistake, I sent out an email, we discussed something, and it's on my personal computer.
Mm-hmm.
You have any idea of how much of a chance you have to look at my personal computer without my taking a hammer to the hard drive first?
Yep. I hear that. I'm sure you're speaking hypothetically.
I am, absolutely hypothetically, because I don't send out those kinds of
Right,
emails.
and
Just like in the IRS,
that's,
it's not on your hard drive.
I feel like you just like loved to soften to me, because that's exactly right. And that is exactly why I recommend lots of different things. One is, you know, I joke about the New York Times principle. You know, every time, or the Kennebunk Post principle, whatever you want to call it, every single time you send an email, go through this process of, should this be my outside voice? You know what I mean? And if this is going to end up on the front page of the Post or wherever else, am I okay with that? That's the first question you ask yourself. The second question is, you know, is it a public record? Because most likely it is if it has anything to do with public business. And if it's on your personal computer and not, you know, the town's, is it still a public record? You bet it is. And if somebody was like super keen on getting that email and it wasn't on the town server, and we'll talk about that in a second, can a court order you to produce your computer? Yes, they can, if it no longer exists because a sledgehammer has been taken to it. I would not recommend that, but
Of course not.
right.
And
But what I'm saying is, be very careful. And you know, what I recommend for all of our towns, and you know, some towns don't, but it's good practice for a number of reasons. The very reason you mentioned, but is for every board member to have, you know, lreachin at townofarundel.org or whatever your thing is, instead of leahreachin at yahoo.com. Because I don't want people going through my Yahoo account. I really, really don't. And if you can say to a judge, Your Honor, every single email that I conduct town business on is on the town server, that alleviates your concern, and it also allows the very lucky Freedom of Access officer not to have to ask everybody for their personal computers, or for them to each of you do those searches yourself when they come in. It basically allows, you know, your IT person to look through, or whomever has that very unfortunate job to find them. But you're not asking everybody for their personal emails. So that is, you know, if there's any like practical takeaway from this, that would be a good one. All right, let's see. All right, I think we don't have to go too much into the nitty-gritty of the right to know when it comes to this kind of stuff, because your friendly Freedom of Access officer, if he has a question, can ask his friendly attorney about that.
Just to be clear, though,
Yep.
if there's a communication between two board members,
Yep.
that's not public record.
It absolutely is. I think what's happening is
it's
you're
not-
Three or
it's
more.
not-
You're
no, no, it's
confusing
not a
public
meeting.
record with public meeting,
Meeting.
right? So if anything, if you're talking to one other board member regarding something that is a transaction of the public business, it absolutely is a public record, but you don't have to worry about, now I'm in public meeting land.
Meeting, okay.
All right, yeah. And that's a totally legitimate question, because it does get confusing.
Question,
Yes,
when, or if, an email sent out that asks you for your opinion, and when you're polling something, whatever the question is that considered a meeting or
well, let me ask you this, again, purely hypothetical. If you're talking about polling your opinion on something, is that something, an agenda item or something, or is it more, hey...
it could be an agenda item?
Yeah, if that's the case, then it is definitely both a public record, and if you've got a bunch of board members talking about their opinion, don't do it. I mean, that's a violation of the public proceedings piece, right? Remember we talked about the two prongs? So let's follow that through. Say there's some hot issue some board and you've got a 5-person board and, hey, what do you think about X? People start talking about it. Not only is that a public record because it's about public business, and then that could be requested and produced and say, well, wait a second, everybody's expressing their opinion. I, as the applicant, never had an opportunity to address your opinion and try to change your opinion or give you information. Also, it becomes a public meeting, because if more than, say you got 5 people, if 3 people start engaging in that dialogue back and forth, that's a meeting, that's a public proceeding, and it should happen in public.
What I'm saying is not necessarily back and forth.
Yep,
Just turn around and, you're throwing out a question, okay?
yep,
And you kind of reply to the question
yep.
to get either an opinion or not.
Yep.
But not turn around and chit chat
I
back and
totally
forth.
understand. Let me give you, sometimes there's a black and white answer, very rarely. But I would say that in that case, just don't do it. Unless you're talking about where the meeting's gonna be, oh shoot, I'm gonna be 15 minutes late. Anything about the substance of anything before you, what the law says is you have it in public, so the public knows. And that's what the law says. And, we can all debate whether or not that makes sense or not, but I'm just telling you what it says.
Okay.
Okay? I heard I might ask a question. No? Okay. Let's see what else we got here. In the vein of decisions being made and people knowing why, this is a question, this comes up a lot, and in fact there was a case about it, the whole concept of site visits, and I know a lot of it has to do with planning boards. Sometimes boards of appeal go on site visits. So you know that, and this is along the lines, I think, of kind of doing your own research. So you know that a particular property is either subject to planning board approval, or if it's Board of Appeals, and you decide to go to the site. And it's not a publicly noticed site visit. You just go. And you notice, well, they said that the contours were like this, or they said, you're just seeing things that, I've kind of laid the foundation here. What do you think about that? You think that's something you should do?
No, I think it's a bad idea.
Why?
Because I'm going there as a representative of the planning board, and there's nobody else there, and we're not having a meeting. That's just a horrible idea.
Well, never mind, possible trespassing.
Yeah.
Never mind that.
Other than that,
But it's back to that, it's basically back to doing research. And again, if you did, then you just disclose and say, I did this, I saw these were my concerns. What do you have to say about it?
Well, I think you have to think in terms of what your purpose is in going. If your purpose is to investigate the application, then that's not a good idea. But if it's a place of business where you happen to be going and they happen to have an application, you happen to notice things, that happens.
Well, sure, and that's why if you happen to notice things that concern you or you notice, then you bring it up.
Right.
That's not a problem.
Yeah.
So what if planning board has a site walk and one individual can't make it, or a couple, we'll say one individual can't make it, and they come to the planning board meeting and the applicant says, yeah, swing on by anytime if you want to come over and check out, you couldn't make the sidewalk, but swing on by anytime.
Yep.
I've heard that
Yep,
before.
yep.
Is that okay?
I think, again, if they couldn't make it, I guess the point that I'm trying to convey is that if you're going to do something outside of the context of the meeting, then just make sure that if you see something that raises a concern, or just disclose that and give the applicant an opportunity. Again, I understand we don't live in a perfect world, and sometimes imperfect things happen. But, in life, in parenting, in your job, it's how you deal with those imperfections that, that's how you how you stay out of trouble. Right? Okay? Site visits, we talked about that. Oh, another one, this is a good one. And this, I'm sure, to do with selectmen, planning boards, boards of appeal, happens all the time. You're in the grocery store, the applicant sees you there, and man, oh man, he sees you, and you're in the produce aisle, and he is right there. He wants to talk to you all about his application and why this particular project is going to benefit the town and all the jobs that it's going to bring, and you're on the board and you're making that decision whether or not you're going to do that. Anyone, thoughts? Bueller?
I'm gonna tell him that if he wants me to consider that, he better go away right now, or he will not like the end result.
Or,
You
that's
bring
one
it,
way.
you bring it to the
Right.
planning board.
Sorry, but I can't discuss it, you should bring it to the board.
And I would say that that is another way of dealing with it. Yeah, diplomacy is always the best way, and, or maybe, actually, I shouldn't say diplomacy is always the best way, but I would suggest that if that happens, you definitely say, look, I can't wait to hear all about it at the planning board meeting next Thursday. I mean, that's what you do.
Yeah, it's just.
But we're talking only about active applications, not possible applications, not past applications.
Yeah, I mean, past is kind of water under the bridge, unless, of course, you've got phased developments and that, I mean, again, there's an exception to every rule. I'm trying in the next half an hour to kind of lay the foundation for the best practices and basic stuff. But again, best practice is just don't talk about it. Just refer, do it at the meeting, all right? What do we got?
I mean, we can't play crystal ball,
Can't play crystal ball.
we're looking at pockets, see what's coming up.
All right. All right, let's talk about conducting hearings and the decision
What
making.
else they do? What do you, Board of Selectmen members, we get calls at home.
Oh, gosh, I do. Yes, I do. I'm sure you do. All right, so let's talk about that.
So maybe it's not even on
But
the
Mr.
agenda.
Dan,
items.
like, you're my
Right.
elected representative, and I just really need you to help me with this problem. And actually, let me, I'm gonna email you. Mr. Dan, like, I really need you to help me with this problem. I'm having this horribly embarrassing health issue, and I can't really come to the meetings because I have X, Y, and Z condition. And oh, by the way, this is my social security number, so can you, I mean, are those public records? I mean, it's about public,
Yeah, send that social to me.
I mean, and that's a public record, right? Right, it's about public business, right? No, it is not. So now it's an exception because you're dealing with health issues, you're dealing with social security numbers, but I wish I could help you, Tom, wish I could say, oop, can't talk about that unless it's a pending application. I mean, and you guys don't always, you have licensing stuff or liquor licenses and that type of thing, but you're not always in the capacity of a, could always get called a
Can't hang
slave.
up.
Called a slave for me. But that's the difference, because if you're not in that position of being the judge, if you're not sitting in judgment of an application, then you can talk about it, right? And they can talk to you about it. Yeah, I know, so much, sorry.
Is it really a good idea? I mean, if I'm on the planning board and we've looked at an applicant and we've approved them, and 7 months later they want to get together and talk about it, I'd rather not talk about it, because I don't want to deal with that. I don't want to bring it back up. I don't want
Right.
to give you the wrong impression of any kind. I may have been one of the people that voted against it, and they want to come and chew on
Right.
I don't want to hear it.
And to me, that's a different issue, like, I hear that, why would you? I mean, life is tough enough.
Yeah, let's
But
be-
is that a violation of the right to know law? I don't think so.
Do I have a right to tell them to go away? Because I don't want to talk to them?
You do, but you're also
I'll
part
be
of,
polite about it, but I'm just, no.
but you're also part of this community, and you talk to people and you work with people, so,
But I tend to look at that the same way I do in my professional field. I cannot talk about certain things in my professional field with other people. And I look at being on the planning board, these are one of those things, we're gonna discuss it here in this room, we're gonna reach a decision, and I'm going home, and I don't wanna bring it up and talk about it again.
I think that's fair, and that's a fair approach. Whether you're legally required to do that after the fact, no, I don't think so, but it sounds reasonable to me. So let's talk about those things. Every single one of these boards, whatever board you serve on, is a creature of statute or ordinance or state law. And that means, guess what? You can, and here's a passing the buck, sorry, I can't talk to you excuse, right? If it is not within your jurisdiction, that's the first threshold issue you gotta look at. Hi, okay, it's 7 o'clock, we're opening the meeting, nice to see you all. Before us this evening, we have a fill in the blank. Well, you don't just go into it. You actually have to say, okay, we have an application for blah, or we're going to listen to this application. you gotta actually have the authority to do what whoever's before you is asking you to do. And I'll give you an example. Let's see. Board of Selectmen, they come to you for everything, right? I mean, but one of the things you could just say is, I don't have the authority to do, I don't have the power to do what you're asking me to do. It's not within, the charter doesn't allow me to do it, or state law, I have to be authorized to be able to give you the relief that you're seeking, and I'm sorry, I don't. A big one that happens is a planning board situation, where you've got an application before you, and someone just doesn't meet the setback, or they don't have enough road frontage. And they're like, well, can I have a waiver? Can I have a waiver? Can I have a waiver? And I mean, it seems like it's only an inch, what's the big deal, you know, come on. Well, that's not within the planning board's jurisdiction. They have to go to the Board of Appeals or the Board of Adjustment, Zoning Board of Appeals. That's their bailiwick. So these are the kinds of issues that jurisdiction, you can't, if you ain't got it, you can't do it. I mean, that's really what it's all about. So that's the threshold issue.
Unless it's written in the ordinance that they have the authority to waive it, right? Because there are certain sections of the ordinance that the planning board has authority.
Absolutely, and there's a big difference. I mean, there are many, many things that the planner can waive. In fact, you can waive pretty much everything unless it's a land use dimensional standard, frontage, density, setbacks, those kinds of things. But they come before you all the time as a planning board member, and you think, well, what's the big deal? I can waive this traffic study, and I can waive this submission requirement. Why can't I waive an inch? Well, because the judge says you can't. Okay? I mean, sometimes that's really the only answer. What else we got? Okay, threshold issues, jurisdiction. We talked about conflict of interest, and I think it's worth repeating. You've got these two concepts. You've got conflict of interest, you've got bias. They sound like the same things, and quite frankly, they're very, very related. The concept of conflict of interest really has to do with money. Has to do with, do you have a financial interest in the issue before you? And you've got, I was looking at state law, the definition of conflict. I was looking at the charter. I think the Board of Selectmen has a code of conduct. I mean, believe it or not, the definition, of course, is different in every single one, right? But in order, and I know it's getting late and you'll glaze over, and I'm not going to go through the definition every single one, but here's the golden rule. Listen to that gut. Listen to that gut. Like, the case law says, and this is actually a good one, I like this. It says, when a board member, this is a conflict of interest, when a board member is placed in a situation of temptation to serve his own personal interest to the prejudice of the interest of the applicant. Okay? That's really it. If you are in that position, you think, if you start feeling that feeling, that's when you disclose it and you recuse yourself. Or, alternatively, sometimes you don't really even have to recuse yourself, but disclosure, disclosure, disclosure. And in every board, you are basically a self-policing mechanism. So you raise it, and if you're on the fence, I don't know, what do you think? I mean, some things are just clear. There are things that are black and white. This is my company, it's my son's company, I own 50% of the stock. You don't sit on the board. If it's a situation where it's questionable, you put it out there, you let your fellow board members debate, deliberate, discuss, and you vote. And another situation is that duty only to yourself? What if you know the guy next to you, his son's the applicant? Well, what do you do in that situation? Okay, what should you do in that situation? Let me rephrase.
Advise them to recuse himself.
Yeah, and that's very tough. That's really awkward. I'm not saying it's easy. But I'll just tell you that the duty is not just as to yourself. It actually applies if you know or have reason to believe that the person sitting next to you, because it's all about the integrity of the process. And if that is the situation, okay, so let's talk about worst case scenario. What happens if, in fact, somebody has been deemed, and deemed has to be by a judge. All these things have to be determined by a judge in the end, which gets expensive for the town. What's the upshot? Say somebody makes a decision that they shouldn't have. They should have recused themselves.
It's kicked back up. Comes back to the planning board.
Maybe.
Overturn the decision.
Yes.
Yeah.
I mean, the judge won't, you're right, it goes back. It'll void the decision and it has to go back for consideration by a board that is not biased or has conflict.
Leah, before you said conflict of interest is financial,
Yeah.
and then you read the definition,
Yeah.
which sounds broader.
Yes,
financial.
that's exactly right. So there's conflict conflict is, generally speaking, if you look at state law, I think probably the selectmen's also has financial criteria about what a conflict of interest is. Bias, on the other hand, is family relationships. There's this ridiculous definition in the statute that talks about if you are related to somebody within, I think it's the 5th or 6th degree of consanguinity. Okay?
Favorite word.
I don't even know what that means, okay? But what that means is if you're related to somebody and they're before you, supposedly there is a bias issue. Now, we all live in a small town, and 5th degree of consanguinity, that's pretty tough. So, again, practical. Disclose it. They're my 5th cousin twice removed. I haven't seen him since I was 3. Am I good here? You know, that's the kind of thing that we do, okay? But whether it's money, whether it's relationship, whether it's back to the whole, I've hated this person since kindergarten, those are all the things that if you feel that, or if, God forbid, you have said that publicly, make sure you don't sit on that panel. It's just, in the end, it's just the better thing to do for everybody, including the town, who's going to have to pay for the lawsuit if the applicant catches wind that you did say that in public, you know.
Well, going back to conflict of interest, on the planning board, you define that as financial, but on the planning board, if you are an abutter to the applicant, that's
Yep.
considered conflict of interest, but that's not really financial.
Right.
So are we doing the right thing or not?
I think you're always doing the right thing when you err on the side of caution of saying, I can't be, we can call it conflict of interest, we can call it bias, we can call it bleh. It doesn't matter what we call it. The whole point is the process and the fairness of the process and the objectivity of the people sitting in judgment on the application. So err on the side of don't sit.
Could be financial, John, depending upon what it does to the value product.
Right, that's
Yeah.
true.
And I believe it goes down further to say the perception
Thank you.
of conflict. So
He's
if
been
I'm,
here before.
so if I'm living next door,
No, but I'm getting
The
to the
rest of the
financial.
town would say,
You
no,
mentioned
he lives
specifically
next door.
financial.
yeah.
And that's not, well, it could be financial, I
So there's a
suppose,
perception.
in the long run,
Right.
but it's not directly financial.
Right, but again, it's really about broad concepts here. It's about if there can be any perception. It's not just if you have one, it's if there could be a perception of one. And again, I understand that's extremely broad, but we have to import some degree of reasonableness. And that is why, if you think, I'm not sure, just put it out there and let your board discuss it and make a decision. Okay, where are we time-wise? Go ahead.
Just clarify,
Sure.
funny points,
Yeah, yeah.
okay? Would you call conflict of interest to say an old girlfriend?
Depends on the relationship. I guess.
Well, I mean, but it may not be your 5th or 6th.
Right. I absolutely agree. I mean, I think
Versus
that,
a young one?
I think that, you know what you have to do?
Long time past.
I think what you need to do is have one of those out-of-body experiences and say, how would this be perceived if I sat on this panel? And even, again, if it's questionable, you just put it out there. And you discuss it, and a decision is made. And I think really the critical piece is that it's about disclosure. It's just about disclosure. Because then nobody can say, he always hated me, or it's not just about the girlfriend if you decided against her, it's the abutter to the girlfriend who said, maybe she was that young, beautiful one, and you always liked her, and you loved her, and you still love her, and you can't be objective about this application. So it cuts both ways, right?
I'm just throwing that out as a...
Girlfriends.
Hundreds of- That's
All
not
right.
what my wife says.
All right, I think I should move on.
But
Okay. All right, yeah.
what about bias, though? Because that is very, very nebulous.
Yep,
Everyone is biased.
absolutely.
So where do you draw that line?
You do with your bit.
Yeah, I can't give you any other guidance other than what I've had, is that if you feel like you yourself are questioning it, or if you were having an out-of-body experience and you were looking at this situation, trying to be as objective as you can to say, that doesn't seem right. That's all I can tell you. And like I said, if there's any question, put it out there, disclose it, let your fellow board members weigh in and say, that's not an issue, or yeah, maybe you better step off. Now, if we want to talk about practicalities, let's talk about quorum, because what if everybody has a bias, right? And I've had those situations where in small towns, everybody's related, you got a cousin here and somebody's got a stake in that business. That's when you start having to really do the reasonableness factor. As long as it's out there, it's disclosed, and then if there's an application before you, you got to act on it. So sometimes you may have to deal with a bias situation or a conflict situation. But again, as long as it's out there, that's really sometimes it's, like I said, it's an imperfect world and you got to deal with it. But
Can I ask a question?
Sure, of course.
We've had a couple of instances where there's been applicants in and there's been either the conflict of interest being the butter, or I won't say the bias, where then we've ended up with less than a quorum
Yeah.
in order to do the application process. So the applicant has been delayed a couple more weeks and.
okay, so it's not like
had to
you
come
couldn't
back.
have a quorum, it's just you couldn't have it that day.
Correct.
Fair enough, yeah.
Can that decision with disclosure go to the applicant? You know, I am your abutter, I have ruled on everything positively on your behalf, but in order to proceed tonight, I'm just.
I think you could, but that's not ideal because we know that things go south. And again, I'm thinking like the lawyer who get that case, God forbid, if that came down the pipe. I mean, to me, that would be my first thing to say. They agreed to it. What's the problem here? But again, if you can find somebody who isn't, if there's an alternate, I would say. Now,
In that case, there wasn't.
yeah,
I mean, this is, say, here it is,
yep,
we're supposed to have a board,
yep,
and not everybody showed up.
yep.
And then so the fact is that, and the applicant is sitting there and he gets shoved off for another 2 weeks.
Yep, and I would say, again, I'm talking about puppies and rainbows in best case scenario. I mean, if you were asking me as a town attorney what I would say is preferable, I would say wait a couple of weeks. If, from a practical perspective, you think that that's not, the ground's gonna freeze and the foundation's halfway in and all that stuff, then you do what you do, but understand that it could have repercussions, that's all. Makes sense? Written conclusions, findings. I don't even know what time it is, and I don't know what time you said.
It's
it
10:08.
Okay, so I will shut up whenever you tell me to.
The glaze factor. Keep
Yeah.
your eyes around
I
them.
mean, how about this? I'll shut up, and why don't you just ask me questions? Okay, that's not.
One thing that's happened, and this has happened a lot of times over the last 20 years,
Sure.
and we have a town manager form of government.
Yes.
And if there is an issue with a board or if there's an issue with an employee, I think a lot of people don't realize that, you go to the selectmen, they really should not be doing anything. They should be saying,
Absolutely.
you need to speak to the town manager. This is an
Absolutely.
employee
Absolutely.
situation, and I think that happens a lot.
It happens every
More
day,
too often,
in every town, all the time.
Yeah.
And you're absolutely right. You have a town manager form of government. I'm sure it says it in your charter. State law is explicitly clear that, you're not trying to deal with employee issues through the Board of Selectmen. Like, that's just not what you're supposed to do. It happens every day. But you're absolutely right.
But if I may, at
Yeah.
the same time, you have to also give the public the right to speak their mind in a meeting, making the board understand that the board is not making a decision on it. Somebody is insisting they want to come to the public meeting to express their opinion, which they are allowed to do.
Well, it kind of, that skates a line pretty, quite frankly.
Yeah.
Because the employee might not be there to be able to respond
Well,
to
exactly
anything.
right. So this does talk about executive session, talks about personnel records, all that stuff, all statutory. So let's talk about it, all right? So I would imagine on select board, you have an open mic or, open to the public kind of thing. And somebody comes up and says, I hate Simone, she's the most horrible clerk, she just doesn't do her job right. Ridiculous, but I mean, that's the scenario, right? That's tough because people should have the right to say what they want to say, but there's also this whole, what if they wrote it in a letter and said exactly that, Dear Town Manager, all the reason why Simone is horrible and she should be terminated immediately. Is that a public record?
Yes.
Yes.
Guess what? Believe it or not, it is not. And everything I told you, it's about the transaction of public business. Yes, it is. Shouldn't it be public? Absolutely. Now, there are probably hundreds of exceptions to public records. One of those things is a personnel record of a municipal employee, and that is defined as anything that is a charge, an investigation, an allegation of impropriety. Okay, those documents actually, by statute, are confidential and should not be disclosed. They're not public records, okay? And the other thing is that the whole executive session piece is that personnel matters. Do I see a hand? Okay, let me finish this and get right to you. Personnel matters, I'm not going to say should, can be had in executive session. Now, should the process, if you want to discuss a personnel matter, that threshold is you should discuss it in executive session. Now, there's, like every statute, there's an exception to the exception. Should be discussed in executive session, except if the employee, him or herself, says, heck no, I want this out in public. So they can certainly choose to have that, because maybe they say, I want this aired, I want this aired in public. So that's a tricky one. Yep. Oh, hold on.
I know, you're
There's
right,
one
I'm
back
sorry.
there first. Yeah.
I just want to clarify, because we went from someone coming to a town, to a selectman meeting, to somebody giving a letter. And I think I need to be clear. If someone sent the town manager a letter
Yeah.
complaining about an employee,
Yeah.
that becomes part of his record, a personnel record, or
Yeah.
whatever they do with it.
Yeah.
But if someone comes to a selectman meeting and reads that letter at a selectman's meeting,
That is
Yeah.
not in our possession, so we have no idea.
Yeah, I mean,
what-
I
Do
hear
you shut them off?
What's that?
Do you shut them off?
I think you.
well, and if they hand it to you and they say, they read it to you and they give you all a copy of it, you know, at that point, see, and this is why I say yes, when you asked if it was public record, because you were talking about it happening at a selectman meeting. Because if it happens at a selectman meeting and it's done in the public, then at that point, that letter that's given to all the selectmen is public record, is it not?
It's on,
I
Or-
think, well, I wouldn't say it's necessarily public record. I say it's a record that has been made public, but it's a different thing,
Well,
right?
You know what I'm saying?
I do,
That
I
is-
do.
it's-
But let me say, just because it has been broadly distributed when it perhaps should not have been, does not mean it's a public record, which does not mean that somebody comes to town and say, I want that record that was read. Then I guess what you say is watch the tape. It was on, but that's not, it's still not a public record.
Right, because
And again,
the only public record isn't it just the minutes?
Say that again?
When you're at a selectman meeting?
Well, yeah, the
that's
minutes
for
are
the
public,
minutes.
but for example, if an applicant, if there's a licensing thing, any papers,
Yes.
that's public. But yeah, I mean, and that's a tough one, and I can't say because every situation is different, and if you see it going down a road that is just getting a little too inappropriate, then the town manager or whomever, the chair of the board that it was at would say, look, this is a personnel matter, and it's a town manager plan, and, we need to govern ourselves.
I just wanted to make sure that I clarified the two.
I understand, they're two
Difference.
separate things, and one is far less black and white than the other, so, yeah.
I'm confused for a second, okay?
I'm supposed to make you not
Yeah.
confused.
Okay, well, we'll wait.
Thank you.
Second door, we're next.
Yeah.
You said if a letter is sent, say, for example, to the town manager, that's not public record.
No, it depends on what the nature of the letter
But
is.
what I'm getting at is,
Yeah.
if it was not public record, okay, but if it was an email sent, it would be public record.
No, I think,
That's where I'm confused.
okay, letter, email, napkin, okay, it doesn't matter. What I'm saying is that the general rule is, if it's about anything about public business, transaction of public business, it is a public record. But if it is a specific exception to the public record rule, and there are many, and unfortunately, even though the Right to Know Committee has been trying to compile a list, Still haven't done it, but that little handout I gave you, at least they give you the most common ones, the most common exceptions. So yes, general rule, it's public, but that's why you have your freedom of access officer when it starts to get, ooh, we got some health information here, ooh, we got some personnel information here, ooh, we got social security numbers, we've got those kinds of things that common sense would tell you. That's when you go see,
Okay, thank you.
yeah. Yep.
So, getting back to executive session, you talked about individuals that would say, no, I don't want it in executive
Specifically
session.
only on personnel issues.
Right.
Yep.
So, but that individual would have to know that the board is going on executive
Yes.
session, right?
Yes.
Because most often they
Yes.
don't.
Yes.
It's just,
To
for
discuss a
personnel
personnel
matter,
matter.
right.
Yeah, yeah.
so,
Then I think, and I'll tell you, that's a tricky one because different, and you joke, you ask 10 different attorneys, they'll give you 10 different answers. But I think if you called MMA, they would tell you that even in the executive session, notice, it should be reasonably calculated to tell you what it's about, and not just a personal matter, which, other attorneys would tell you something different. So, that's tough. But again, executive session. So you go into an executive session. The nature of the business has to be stated publicly. They go off into their separate room or the public leaves. You talk. Can you make a decision in that executive session? No. It has to come out and you have to say what exactly right. So,
And the committee is not allowed to discuss it after the fact. It's not
I
public.
think that's exactly right. What if you have notes that have been taken in the executive session? I say don't take any notes. What if you take notes in your planning board meeting and you're taking notes, is that a public record?
If you keep them,
Right, exactly right. And so, I've had, again, those really contentious projects that come up, and there have been record requests where they say, I want everything related to, including but not limited to, personal notes of planning board members. Let me tell you, that has caused some embarrassment. So, know that they're public, and if you're doodling, make sure you're,
you throw them away when you get done.
yeah, did not.
you mean artwork doesn't count?
What's that?
Artwork doesn't count?
That's public record.
It can count against you, Marty.
If it's on your notes.
It can count against you, Marty.
I'm not pretty enough anyway.
Yeah, it's it's a minefield, no doubt. But by the same token, the courts understand and hopefully appreciate the fact that people, volunteer boards are serving for countless hours. They're getting so richly compensated for what they're doing that, I'm giving you the parade of horribles. I'm giving you the best and worst case scenarios. Certainly, that's my job, and I think it's important to be mindful of those things. But again, sometimes there aren't going to be enough people who show up, and maybe somebody has a cousin twice removed. You just do the best you can with what you got, but be mindful of these concepts and trying to navigate through them the best you can.
The employee issue, can the employee insist upon being participating in executive session?
If it's about them.
Yeah.
That's exactly right, and I think that's really important to make sure. So you say executive session to discuss a personnel matter involving the town clerk. All right. Guess who hopefully is going to say, "Hello, I'm the town clerk. I'd like to be there." Right. And there's another thing. Well, it's too detailed. We'll go there. But town clerk wants to be there. It's about her. She has absolutely every right to be there, and she has every right to say, "Oh, no, you don't. I want this in front of everybody," and if she says that, then it is. Fun stuff, huh? Good thing is if you need to consult with the town attorney, it's always in executive session. It can be. I think the lawyers may have written that statute, but
Is that a matter of opinion?
not
No.
my opinion.
It's a legal opinion.
Yeah, that's right. Yeah.
I'm saying that because.
Oh, there's one. Sorry, go ahead.
I'm on the planning board, so we're never gonna have that problem. But, well, we're not going into executive session unless we're
We
discussing
can.
each other.
Well, you can actually. I've been to plenty of planning board meetings where there's a discussion about what are the rights and duties of the, say there's maybe it was a question about, is this is this actually a waiver or is it a variance? You know, because sometimes those lines are actually blurred. And say you might not request the pleasure of my company, but you might request a legal opinion. Is the legal opinion a public record? Because
No.
everyone thinks, oh, attorney-client privilege, right? Guess what? Not in municipalities. Enter right to know law, right? So if I issue a legal opinion to the town, and there's a footnote here, of course, there always is, it is a public record, except if it is with respect to a matter that is actively in litigation. If it's in litigation, if there's a lawsuit going on, then we're back to attorney-client privilege land. But if not, then it's public.
Just to Rich's point, if I may,
Yeah.
my former municipality, with the planning board, we had an executive session with the town attorney to debate the meaning of the word shall as written in our ordinance. And it was a 3.5 hour long executive session. To
But
debate
that's
the
why
word
our planning board
shall.
meetings are as long as
Yes,
they are.
the word shall and where it was placed in a sentence and whether or not it prohibited someone from doing something that they wanted to for 3.5 hours.
Oh my.
Yes.
Well, my question would have been more from a Board of Selectmen point of view. If they're gonna discuss me in an executive session and I'm not in the meeting to find out that they're gonna discuss me in the session, do I have recourse? Should they not tell me they're gonna talk about me? Or can they just do that?
That was kind of my question.
Planning board member or you?
Yeah, who are you? Are you a planning board member?
I am,
Well, then I think that,
appointed by these guys.
yeah, that's a tough one. That's a different ball of wax. Yeah. But I guess my advice is always just to err. It's better to give people more rights than less, because then,
I want them to invite me because I want to hear what they have to say. Because I can add fuel to that fire.
but let me say one thing, is that if things are about an employee, say, then that employee has the right, blah, blah, blah. But if the question is, how do I deal procedurally with this employment issue?
Right.
Guess what? Lawyer comes, employee isn't there, but that lawyer has to be very careful about not going into specifics about, it's just about process, and this is how you do things, and if you were interested in discipline, this is how you would have to do it, that kind of stuff. Looks like everybody's just invigorated by this discussion. So,
I have to say that this is a little different, because I sat on the school board, and I don't sit on it anymore, and their discussion on meetings, what constituted a meeting between school board meetings, between school board members, and social media was far different.
well, different people will tell you different things, I'm sure. And one thing I will say is that, you know, let me ask you this. If Tom and Todd want to sit down and shoot the breeze about agenda, is that a public meeting? No. If two school board members want to have a cup of coffee and talk about, you know, the expansion project, is that a public meeting? No.
Not because they don't have three.
It has to be a quorum of the board. So,
Okay, so
Has to
that's
be a
where the
quorum
three
of the
comes in.
board?
It has to be a quorum of the board, it's not necessarily three.
I think state law actually says if it's 3, say your board is 7, 3 is still,
Okay, because see, they were discussing a quorum, and everything I had learned prior, because I've spent things forever, was the 3 board.
let me tell you this. Quorum is a moving target in the sense that every board can have a different quorum because you have the authority to adopt your own bylaws. And that's a bylaw issue, that's a self-governance issue, but charter dictates. Whatever your charter says is the organic law of the land, and it even trumps state statute. So that's where those differences could arise, is that your bylaws could be different from what state law says, your charter could say something different. So every board has a different quorum, and that's legit.
So your RSU would have to go by your statute that governs RSUs.
There's nothing in our charter for the RSU anymore, right? There's nothing.
No charter.
There's nothing at all on the school that I charter.
Yeah, I mean, and then you've got school law, which has its own title, and you know better than I do. So those differences make sense.
Okay, John, confused over there. I can see the look in your face. On quorum.
I mean, some,
I'm confused.
some say
It's a
quorum.
3 rule is the basic rule.
That's what statute says.
Right.
But that doesn't mean that
But that
your
quorum
charter.
doesn't have to be 3. But
Have a meeting, you have to be
is
3.
I think we're confusing quorum and what constitutes a public meeting.
Right.
Right.
No, I'm not, I
Yeah.
didn't think I was confusing it, but.
Well, I just want to make sure everybody's clear that that's what the difference is.
Okay.
Yeah.
So you're saying if you have a board of 7,
Yep.
if you have 3 members
3 members where.
and a plan board, that's a quorum.
No,
No.
it's based on your bylaws.
On the
Right.
bylaws.
That's where I'm trying to,
It's based on your bylaws, but if you have 3 members talking together, then you can't have that.
That's a public meeting.
That's a
Yes,
public meeting.
that's what I'm trying to say. There's the 2 different concepts, and again, it's so confusing because they get all tangled up. But quorum is a concept simply to say how many people of this board have to be present so that we can conduct business. That's over here. The 3 rule is if you've got 3 members of any board, no matter how big that size is, that's a public meeting that has to be noticed and everyone has to be allowed to come.
So discuss the hypothetical bean supper, let's say. Leah.
Okey-dokey.
That might get,
Yeah, let's talk about that. You give me the hypothetical,
well, just to bring your point home.
right?
You have a board of selectmen, I'm
Yep.
not picking on the board of selectmen, but you've got 7 members of the board of selectmen.
Because they're awesome and they go to bean suppers,
Yeah.
You'll get five.
right?
I'm sorry, 5, we've got 5.
I know.
You're talking about the planning
No,
board.
it's planning board.
So we've got 5 members of the board of selectmen.
Yep,
Let's say the bylaws state that 3 is a quorum.
yep,
You have a bean supper, there's 4 of them at that bean supper.
no problem.
No business being conducted.
Right, totally kosher,
7 members of a planning board,
yep,
4 of them are at a local watering hole enjoying
Totally fine.
adult beverage.
Yep.
really a meeting.
So there's, so that's where the
Totally
line,
fine.
it's all about conducting business.
it's about conducting business. You can all hang out, have a grand old time, just don't
Well,
talk about the agenda items.
We had a situation before when we had the school board. We had, all of a sudden, one of the school board members said, oh, we're gonna have a little workshop at so-and-so's camp, and then we can have a family picnic and swimming at the same time, or whatever, and we're like, you know, you have to advertise this. Anybody is
Well,
allowed
I
to
think a
attend
lot of
at
people
that
think
point.
that. If you call it a workshop, then it's not really
A workshop
a
isn't
a meeting.
Yeah.
And you don't have to take the notes and you don't have to do all that, but you still have to notice it and people have to be able to come.
Yeah.
Do you have to have a big old, extremely detailed agenda of what you're going to talk about that particular day?
You just, you have to post the agenda, but it doesn't have to say much.
Believe it or not, you
Same thing
don't.
with
You
minutes.
don't have to post it?
You have to say, the
Right.
planning board's meeting at X time on this date. Do I think that's best practice? No. I think you should post the agenda. Like I said, more notice is better than less notice, but state law actually doesn't require it.
Yeah, MMA, we asked that question a while back when we had a
Go back,
meeting
tell me
with
the
MMA.
same answer, I hope.
Same answer,
Okay,
yeah.
that's good.
Yeah, 'cause we were talking about agendas and we asked them, they said, well, you don't really have to, you don't have to put out an agenda if you don't want. Or you don't have to post an agenda.
Right, right. But I think it's best, if you have one, it's a good idea.
Yeah, but you have to be prepared.
Yeah, no, you're right, we do.
So, all right, company dismissed. Thank you.
Thank you.
Thank you.
Thank you very much for your